and welcome. I am Mario Barnes. I am a professor and the Senior Associate Dean of Academic Affairs at the UCI Law School, and we would like to take this opportunity to welcome all of you to this panel, Post 9/11 Civil Liberties and Legal Implications. I'd like to first thank our sponsors for this panel, which is the Law School, the Newkirk Center for Science and Society, and the Center for Unconventional Security Affairs. The panel is being presented as a part of the 2011 series of panels dealing with 9/11 10 years after. I think we have a pretty exciting and dynamic panel planned for you. We certainly have put together a wonderful group of experts broadly in the area of national security and civil liberties to address you today. And so I just want to say prior to initiating our conversation that the way the panel will work is after I provide you very brief bios. These are really like legal superstars, but you're going to get brief bios so that we can get right to the substance. After I provide you brief bios, the panel will operate by an initial speaker introducing one of four critical topics in the area of national security and civil liberties broadly, and then we will have a response from the two other speakers on the panel. After we have gone through the four topics, we will then open up the entire panel to questions from the audience. And don't worry, I'm pretty much a strict timekeeper, so we will have time at the end for questions from the audience. And so I'd like now to introduce the panelists in the order that they are sitting. To my right, we have Professor of the Practice of Law, Scott Silliman, who is both Professor of the Practice of Law and Director Emeritus of the Center on Law, Ethics, and National Security at Duke University Law School. Professor Silliman is a double graduate of the University of North Carolina. He received his BA and his JD there. And after his graduation from law school, he spent 25 years as a judge advocate in the Air Force. Great and honorable position. It just didn't happen to be in the right force, which is the Navy. But moving on from that, after he retired as a colonel from the Air Force and assumed his duties at Duke University, he writes and teaches in the areas of national security law, military law, and the law of armed conflict. As of November 2011, Professor Silliman was nominated by President Barack Obama for a seat on the U.S. Court of Military Commission Review, the appellate court that reviews each of the military commission cases from Guantanamo Bay. To my left, I have my dear friend, Professor Stephen Vladeck, who is a professor of law and associate dean of scholarship at American University Washington College of Law. He received his BA from Amherst College and his JD from Yale Law School. At Yale, Steve was the executive editor of the Yale Law Journal and the student director of the Balancing Civil Liberties and National Security Post 9/11 Litigation Project. Post-law school, Steve clerked both for the Honorable Marcia Berzon of the Ninth Circuit and the Honorable Rosemary Barquette of the 11th Circuit. And after his clerkships, he began his teaching career at the University of Miami School of Law, where we first met. And at the time when he arrived at Miami, he was a part of the legal team that successfully challenged the Bush administration's use of military tribunals at Guantanamo in the Hamdan versus Rumsfeld litigation. Steve teaches and works in the areas of national security and the role of the federal courts in the war on terror, and he is a nationally recognized expert in these areas. So I welcome my good friend and look forward to hearing from him. And finally, Dean Chemerinsky told me not to do a bio for him, but in showing you how much I listen to the dean, Erwin Chemerinsky is the founding dean and distinguished professor of law at the University of California, Irvine School of Law, a graduate of Northwestern University and Harvard Law School. He previously taught at Duke Law School for 4 years and the University of Southern California Law School for 21 years. He is an expert in the areas of constitutional law, federal practice, civil rights, civil liberties. He is the author of over 7 books and over 200 articles which have appeared in elite law reviews. He's also one of the most cited law professors in the country. And so, and as you know, he's our fearless leader, and we're thrilled as anything to have Erwin as our colleague and the founding dean of the law school. And so we are now going to actually get into the substance of the program, and we'll first hear from Professor Vladeck, who's going to open up our conversation with a discussion of the role of detention and habeas in the war on terror, and then we will have a conversation allowing each of our other 2 panelists to speak on the topic. And again, our questions will come at the end of the panel after we've covered all 4 topics. Professor Vladeck.
Great. Thank you, Mario. Thanks, everybody. Let me just say it's a real treat to be here, so thanks to Erwin for the invitation. I have a lot to do in 8 to 10 minutes, so I'm going to start in a fairly high-level generality and get more specific as we go on. My goal in the next 8 to 10 minutes is to give you a fairly comprehensive overview of the interplay between detention of suspected terrorists in the war on terrorism, the habeas corpus litigation that this detention has precipitated, and most recently, Congress's second intervention into this conversation in the National Defense Authorization Act for fiscal year 2012. It might be helpful to keep in mind throughout this conversation 3 very different categories of detainees that we'll be referring to. One category, which turns out to be by far the smallest category, but also the most controversial, is individuals who are detained while they are inside the territorial United States, be they citizens or non-citizens. In fact, there aren't any individuals today who are still in military detention who were picked up in the U.S., but this category obviously is near and dear to any discussion of civil liberties. The second category is non-citizens who are being detained at Guantanamo. At one time after 9/11, there were as many as 779 non-citizen men being held at Guantanamo. The number today is 171, but that's still obviously a relevant figure. And third and finally, non-citizens who are being detained elsewhere outside the territorial United States, most significantly the U.S. detention facility at Bagram Air Base in Afghanistan. So these are the 3 big categories we'll be talking about as we go through our brief overview. Obviously, everything starts with 9/11. 1 week after September 11th, Congress passed and President Bush signed into law the AUMF, the Authorization for the Use of Military Force, a fairly sweeping grant of authority that gave by which Congress gave President Bush the authority to use all necessary and appropriate force against those persons he determined planned, perpetrated, committed, or otherwise assisted in the terrorist acts of 9/11. Acting pursuant to that authority, President Bush began offensive military operations in Afghanistan in October of 2001. As I'm sure Scott and anyone else who has this experience can tell us, an inevitable byproduct of offensive military operations is military detainees. So it was not so long thereafter, January 2002, that the first detainees were sent to Guantanamo. We, being the litigious culture that we are, shortly thereafter the first habeas petitions were filed. Habeas petitions, as I'm sure most of you know, are an ancient common law remedy by which individuals in various forms of custody seek a judicial order testing the legality of their ongoing detention. And indeed, much of the law in this area over the last decade has developed as courts have considered habeas petitions filed by the Guantanamo detainees. Now, the next big development is as we are starting to send detainees to Guantanamo, there are also 3 individuals who are picked up in, or at least held in, the territorial United States. Jose Padilla, U.S. citizen, is picked up getting off a plane at O'Hare Airport on May 8, 2002. Yasser Hamdi, a U.S. citizen who was actually initially arrested in Afghanistan, is ultimately transferred to Norfolk, Virginia to be detained once it's discovered he is a citizen. And finally, Ali Almari, a non-citizen, is arrested in Peoria, Illinois, initially on charges of computer fraud. He's subsequently redesignated enemy combatant and sent to a military brig. So you have these two tracks of litigation. The three individuals who are in the U.S. challenging their detention, and the individuals at Guantanamo challenging their detention. Now, the first big development on this front is in 2004. The Supreme Court on the same day decides three cases. In the Hamdi case, the Supreme Court rejects the Bush administration's argument that an affidavit by a single government official is enough to support the detention of a U.S. citizen like Hamdi. The court also, though, says quite importantly for our purposes that the government does have the authority under the AUMF to detain individuals, including U.S. citizens, at least in the circumstances of Hamdi's capture, that is, at least those picked up on the battlefield in Afghanistan. And so that sort of sets the parameters going forward. On the same day, the court in the Rasool decision says that the federal courts do in fact have the power to decide the Guantanamo habeas petitions, and so that sort of precipitates resolving these claims on the merits. Are there any rights that non-citizens have when they're held outside the United States? Is their detention authorized, etc.? The next step after 2004 is Congress gets back into the story. So in a pair of statutes, one called the Detainee Treatment Act and another called the Military Commissions Act, Congress basically attempts to overrule the Rasool decision and preclude habeas review of the Guantanamo habeas petitions. Instead, Congress substitutes an administrative review procedure, something called CSIRT, Combatant Status Review Tribunals. There will be a quiz at the end. And the idea behind the CSIRTs is to function as its own form of internal judicial review, thereby mooting the need for habeas. This all leads to the Supreme Court's 2008 decision in a case called Boumediene versus Bush, where the court holds, no, in fact, Congress cannot do this. That the suspension clause of the Constitution, which says that the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it, compels access to habeas or an adequate alternative. And the alternative Congress had provided in the Detainee Treatment Act and the Military Commissions Act was, for various reasons, inadequate. All right, so Boumediene basically said that as a constitutional matter, the Guantanamo detainees, at least, were entitled to have their cases go forward. What's happened since then has been, by all accounts, a remarkable flurry of litigation in the DC courts about the Guantanamo detainees, about the scope of the government's detention authority, about the relevant rules of procedure and evidence. What the Supreme Court said in Boumediene is basically that it would be up to the lower courts to make these rules up, because Congress had provided no details, no specificity, nothing more than the original September 18th AUMF definition. And so we've had, over the course of the past now 3.5 years, a bevy of litigation in the district court. To date, there have been 61 detainees at Guantanamo who have had their habeas claims resolved on the merits. 38 of them prevailed. Right? That is to say, even after all this time, district courts ruled that in 38 of these 61 cases, the government did not have the authority to detain these individuals. That still leaves 23 cases where the government prevailed. It also leaves the individuals who didn't file habeas cases either because they refused to participate or perhaps because they thought they would be losers. Now, the next step in the story, and the last and most recent step in the story, is the National Defense Authorization Act of 2012. The NDAA has received a lot of media attention, although I think not necessarily focusing on the key provisions. The really big story behind the NDAA is why Congress saw the need to get back in the ballgame. Right? That is to say, you had this evolution of jurisprudence in the DC courts, for better or for worse, where the courts had coalesced around whom the government could detain, around what the evidentiary burden could be, around how these cases would be litigated. You had no claim by the executive branch that their needs weren't being met, that these cases were interfering with their authority, that they didn't have enough authority to detain individuals. And instead, Congress comes along and says, we are going to codify at least what we believe the detention authority should be, which raises the concerns that have been voiced in the media about detention of U.S. citizens. So let me say sort of 4 quick points about the NDAA, and then hopefully that will provoke my friends and colleagues enough to start a conversation. So quick point number 1. On the substantive scope of detention authority, the important part of the NDAA is that it reaffirms what had been the Obama administration's position, but what had not yet been endorsed by the Supreme Court. That is, that in the war on terrorism, individuals can be detained without trial if they are part of Al-Qaeda or one of its affiliated groups, that is membership, or if they are providing substantial support to one of those groups. The part of piece of that to me is not nearly as controversial as the substantial support piece, because one could have a very long conversation about what it means to give substantial support to one of these groups. In other contexts, the federal government has argued that giving money to Islamic charities, if you have reason to believe those charities are indirectly involved with terrorist organizations, might qualify as such support. Obviously, that would be, at least in my mind, reason for concern. Second big point. The NDAA actually resolves, to my mind, in the detainee's favor, an issue that had been opened about the relevance of international law to conversations about the scope of the government's detention power in the war on terrorism. The D.C. Circuit, the Federal Appeals Court in Washington, had suggested in a widely read decision that international law had no bearing on the scope of the government's detention power in the war on terrorism, that the government could detain whomever the government thought it needed to be able to detain without reference to what international law would allow. The NDAA repeatedly refers by statute to detention under the laws of war, and so I think one could argue now that Congress, at least, has added its imprimatur to the notion that whatever authority the government has is the authority that's recognized by international law. We can fight over what exactly that is. Third big point. Section 1032 of the NDAA, the one that really provoked the most consternation from the Obama administration, requires in many cases the mandatory military detention of individuals suspected of being involved in imminent terrorist attacks. Why is that a big deal? Wouldn't we want these people to be detained? Well, it's military detention as opposed to civilian detention. Right? It might take authority out of the administration's hands to have the FBI interrogate someone like the underwear bomber or Faisal Shahzad, the Times Square bomber, etc. The one piece of good news is in the negotiations over the bill, this language got watered down. Now there's mandatory detention unless the Secretary of Defense applies for a waiver. Presumably, the Secretary of Defense will always apply for a waiver, but then I go back to my first question, why was this all necessary? And then last but not least, I saved the most controversial issue for my last piece, U.S. citizens. There's a lot of media attention to the notion that the NDAA authorizes the indefinite detention of U.S. citizens. This to me is particularly ironic because the Feinstein Amendment to the NDAA, which is codified at Section 1031E, specifically provides that the NDAA does nothing to affect the status quo with regard to the detention of citizens or other persons within the territorial United States. That doesn't mean it doesn't authorize it. It just means it preserves the status quo. What is the status quo? Well, here's where things get messy, and this is perhaps as good a place to stop as any. Nobody knows. Right? And the reason why nobody knows is because, as I mentioned at the top, there have only been 3 cases since 9/11 involving individuals detained in the United States. All 3 got to the Supreme Court at some point, right? But in the 2, Almari and Padilla, where the individuals were actually arrested in the U.S., there was never a decision by the Supreme Court on the merits. In Padilla's case, the Bush administration mooted the issue before the Supreme Court could decide. In Almari's case, the Obama administration mooted the issue before the case could be resolved. So the NDAA does not authorize detention of U.S. citizens or non-citizens lawfully within the U.S., but it doesn't prohibit it either, right? Instead, we're left where we started, which is over 10 years after 9/11 and 10 years after the AUMF, still not having resolved these very fundamental questions about who can be detained, under what circumstances, and for how long. Thank you.
Justice Silliman?
Thank you. Thank you, Steve, for a very elaborate setting of the detention issue. Let me just add a couple of things to what Steve has said. Many of you may recall that in the early years of the Bush administration, when Guantanamo Bay started to be populated, is this that many said, well, these folks that the United States is captured overseas, the Al-Qaeda and the Taliban, they should be treated as prisoners of war. you may recall that Manuel Noriega was treated as a prisoner of war who we brought back from Panama. Well, let me suggest to you that as Steve mentioned the interplay between our U.S. law and international law, the law of war, that even if the Bush administration and the Obama administration had said, yes, these people are to be treated as prisoners of war, that the Geneva Conventions would still allow for them to be detained until what we call the end of hostilities. Now, the real question is, when is the end of hostilities when you're dealing with acts of terrorism? Nobody can answer that question. But what was really unique about the evolution of this whole detention issue was exactly how the Supreme Court treated it. You go all the way back to World War II, and there was a famous case involving 21 Nazis that were actually providing information to the Japanese about American military operations. And they were prosecuted by a military commission, which we'll talk about a little later, and they were incarcerated and then basically repatriated to occupied Germany. And they challenged their detention in a very famous case written by Justice Robert Jackson, one of our really very famous Supreme Court justices, who was the chief prosecutor for the United States at Nuremberg. Justice Jackson wrote that with those who had never been in the United States, who had taken up arms against the United States, who were acknowledged enemy combatants, that they had no statutory or constitutional right to challenge their detention in the courts. Well, President Bush's lawyers obviously were very familiar with this case called Johnson versus Eisentrager that said that no one who had not been in the United States, was not a U.S. citizen, had no right to challenge their detention. Ergo, the choice of Guantanamo Bay. Simply because Guantanamo Bay operates under a lease with the Cuban government going all the way back to 1903, and it is not considered, still, even as a result of court decisions, to be within the territorial jurisdiction of the United States or our courts. So that's obviously why Guantanamo Bay was chosen. Now, as Steve mentioned, there was some litigation early on that started in 2004, a case called Razul v. Bush, where Justice Stevens, writing for the court, basically said, when I look at Guantanamo Bay, it's tantamount to what should be in the United States. And what he did was he reinterpreted the case law on the habeas statute, not the Constitution, the habeas statute, to say these people can come into our courts and bring a challenge under habeas corpus. And that's exactly what they did. They started filing petitions in the district court for the District of Columbia. Actually, one of the cases, Garabia, I think Erwin was actually involved in outside of the District of Columbia. But interestingly, as Steve said, then Congress, by statute, in a thing called the Detainee Treatment Act, which most people remember for its provision that you can't torture or create human or inhuman treatment for those who are your captives. But in that act, it basically changed or amended the habeas statute to say, guess what? Everyone can file for habeas except those at Guantanamo Bay. And they actually put that in Section E of the statute. The very next year, the Supreme Court comes along, and again, a case Steve mentioned, Hamdan v. Rumsfeld, and the very first issue in that case was, listen up, Supreme Court, we're going to again tell you, or listen up, Congress, we're going to tell you that that provision in the statute that Congress changed only applies to future cases, not past cases. So all those cases that were filed after 2004 are still alive and well. Then the Congress comes back. This reminds me of a ping pong match. Congress comes back in the Military Commissions Act and further amends the habeas statute and said, guess what? Hear us loud and clear. We intend for no one at Guantanamo Bay to file a habeas petition either now or going all the way back to 9/11. We're making it retroactive, and further, said the Congress, it applies not just to Guantanamo Bay, but also to anywhere in the world where individuals are detained by the United States. Now, then the Supreme Court in 2008, in what I believe is one of the most significant constitutional cases decided in the last decade, held for the first time that non-U.S. citizens who have never been in the United States were covered by the suspension clause, i.e. given habeas corpus to file. Constitutionally, that's a huge, huge issue. But what they didn't do, many of us watching the case going up were saying, are they going to overrule that 1952 Johnson versus Eisentrager case? Are they going to really do it? They didn't. They distinguished it. So that earlier case is still good law. Now let me take you to the next step. Those at Guantanamo Bay clearly have been filing and are entitled to file a challenge to their detention in the courts. But there was a petition that was brought by 3 individuals at Bagram Air Base in Afghanistan who were captured outside of Afghanistan but brought to that detention facility. And they brought a lawsuit saying, guess what? If those at Guantanamo Bay are entitled to challenge their detention constitutionally, so also are we. And Judge Bates, who's a very good judge, District Court Judge Bates, ruled that they were right. Now, the significance of that, again, is huge, because if someone outside of Guantanamo Bay can challenge their detention, that means that any alleged terrorist who was held in detention by the United States, virtually anywhere in the world, could immediately file a habeas corpus challenge in our federal court. It went up on appeal. The Court of Appeals for the District of Columbia, with the Chief Judge, David Santel, writing for the court in an opinion that reads like a law professor would write it, reversed and said, no, the Supreme Court, in its blockbuster Boumediene 2008 decision, did not really say that these particular factors would apply, particularly when you're dealing with an area like Afghanistan, which is still a battle area, which is a combat zone. And he predicated his decision. But what's happening right now, and why all of us are waiting with bated breath, is Judge Santel said in the next to the last paragraph of his opinion, he said, however, if it was shown that the United States was manipulated by sending people to a particular place to avoid the reach of the courts, there may be a different analysis. So what happened? The very good lawyers for those 3 petitioners went right back to Judge Bates and said, we would like to amend our complaint. And we want to amend it by showing that the United States government intentionally moved us to Bagram to avoid the reach of the court. And Judge Bates is about to hear that case. So it ain't over, as they say. These are huge issues. When the Supreme Court gives the constitutional right of habeas corpus to non-U.S. citizens who have never been in the United States, what we're all watching is how far does that right go? Erwin?
Thank you. I just want to take a moment and thank Scott and Steve for coming here from the East Coast. Scott was my colleague at Duke Law School for several years. And I have to tell you in all honesty that the thing that I missed most when I left Duke was the ability to go down the hall and talk to Scott about all of these issues and so much else. And I so admire Steve. He's written many amicus briefs in cases. You're often kind enough to ask me to sign on. And they're always superbly done, and I feel so honored to get to be part of them. And I want to just take one more moment to thank my colleague Joe Demento, because Joe has played such a key role in organizing this series of programs on the aftermath of 9/11. Scott and Steve have done a great job of discussing this issue. I just want to make 3 additional points. First, almost exactly 10 years ago to this day, on Martin Luther King Day of 2002, I and another lawyer filed the first lawsuit on behalf of the Guantanamo detainees. The case was called Coalition of Clergy versus Bush. It's a lawsuit filed on behalf of a group of professors, journalists, and clergy on behalf of the Guantanamo detainees. In February of 2002, I argued that case in federal district court. In July of 2002, I argued that case in the Ninth Circuit. I could not have possibly imagined, when we filed that lawsuit in federal district court, when I argued it in 2002, that we'd be sitting here a decade later and there would still be 171 people in Guantanamo, many of whom have been there for the entire decade, virtually none of whom have ever had a trial or any meaningful form of due process. As Scott alluded to, one of the outgrowths of the Coalition of Clergy versus Bush case, as I began representing a detainee in Guantanamo, Salim Garebi. He arrived in Guantanamo in the spring of 2002. He has been there now for over 10 years. Remember, when we think about this, this is longer than any war in American history. It's longer than the Civil War, or World War I, or World War II, Korean War, or the Vietnam War. And there's no immediate indication that the individuals from Guantanamo are going to be released. Many have been, but of those who aren't, some have been designated for release. In some of those instances, there's problems in terms of whether there's a country that they can go to. Some who remain in Guantanamo are there because the evidence that was gained is tainted by how it was obtained, including through torture. And there's also problems that Congress has created in terms of moving the Guantanamo detainees anyplace else. One of the things that's only been briefly alluded to is that since the Supreme Court handed down its landmark case in 2008, in Moderator versus Bush, there have been a number of rulings by the D.C. Circuit, and all of them have gone against the Guantanamo detainees. In fact, I think that some of the judges in the D.C. Circuit, especially Judge Randolph, have been openly defiant of the Supreme Court, as much as you can imagine any judge being defiant of the Supreme Court, in speeches having said that the Supreme Court was wrong, and the D.C. Circuit consistently saying they're going to give no relief of any sort to the Guantanamo detainees. This has been true in case after case, and the Supreme Court has consistently denied review. The Obama administration, in fact, President Obama promised in January of 2009 they would close Guantanamo within a year. We're now, of course, nearing the end of the Obama presidency, and there's no signs that Guantanamo is going to be closed. The idea that the United States can hold human beings indefinitely without providing due process is something that would have been unthinkable prior to 9/11, and it still should be unthinkable today. Now, during the Bush administration, progressives were willing to criticize the presidency for what they were doing in Guantanamo. Progressives have been unwilling to criticize the Obama administration to some extent, and I think that's a mistake. Obama is much an embarrassment to the United States today, as it was when George W. Bush was president. The second point that I wanted to make is that the number of people that the United States government is now detaining, or has detained as part of the war on terrorism, is unknown. Steve mentioned three categories of people who are being detained. Those who are detained in the United States, those in Guantanamo, and non-citizens detained elsewhere. But it's a mistake to think that that's the exhaustive list of categories of those who are detained. Take, for example, those who have been detained on material witness warrants. We know that at least during the Bush administration, material witness warrants were regularly used to hold people where the government had no desire to use them as material witness at all. There was one man, when I come back and talk more about his case, Abdul al-Kid, who was apprehended on a material witness warrant. Now, there's a federal statute that allows people to be held as a material witness if their testimony is essential, there's substantial flight risk. Well, the government held al-Kid even though it never had any desire to use him as a material witness, never used him as a material witness. He was never suspected of any crime, never charged for any crime. They held him as a material witness because they wanted to question him about a friend who they suspected of terrorist activity. Al-Kid was taken in a maximum security federal prison. At the time, he was held in 3 maximum security prisons. When he was transferred from one to another, it was always in shackles. When he was released, he was put under house arrest. He lost his job. His wife left him. And then no charges were brought, never was a material witness. And this case brought to light that there may be a large number of instances of the government abusing the material witness statute to detain individuals. But we don't know how many. We don't know how many people are being held on immigration charges when it's really being suspected of violations of the war on terror. The Bush administration, until December of 2001, was willing to tell us how many were being held as part of the immigration process because of suspicion with regard to terrorist activity, but then they stopped giving that number. Several years ago, when Michael Chertoff was the head of the Department of Homeland Security, I debated him at a judicial conference, and I said, can you tell the audience of judges how many people the United States is now holding or has held as part of the war on terror if you had all of these categories together? And he said, I can't tell you, that's classified information. I said, I'm just a simple law professor, but I don't understand how it would harm national security if you told us an aggregate number. There was an attempt to get that through a Freedom of Information Act request, but the D.C. Circuit ultimately denied it. And the third, maybe the most important thing I want to say, is that it seems so basic that the government has to always follow the rule of law, even in a time of crisis, even in the context of the war on terror. I think what really explains the Supreme Court's decisions in Rasool and Boumediene that Steve and Scott talked about is that the majority of the court was troubled by the idea that there could be a situation where no law would apply. Because that's what the Bush administration was really saying. They were saying to those who were held in Guantanamo, let alone those who were held in Bagram, that neither the Constitution nor international law applied. And I think for the majority of the justices, that was deeply troubling. And so when you think of Steve's category, isn't it unthinkable that the United States government could detain an American citizen apprehended in the United States for crimes allegedly committed in the United States and not have to provide the Constitution's requirements, such as for due process, trial by jury and the like? Because if the government can do that to Jose Padilla, why can't it pick up anybody and say, we're going to hold you as an enemy combatant and not be able to provide your due process? In terms of Guantanamo, can it really be that indefinitely people can be detained, literally for the rest of their lives? Because President Bush said the war on terror will go on for the rest of our lives and not have to be given due process. And what's troubling about the decision that was talked about with Bagram is how in the world will the lawyers for these individuals ever be able to prove that the government was putting them there to avoid habeas corpus in Guantanamo? And so if habeas corpus can't reach to Bagram, then can't the government just avoid the rule of law and the Constitution by putting people there? So I think that the basic principle that should be what liberals and conservatives both agree to is the government has to always follow the rule of law.
Scott, I promised Steve a brief one-point rebuttal before we get to the next subject.
I agree with Erwin. I mean, I think the only thing I would say is I think it's useful for sort of thinking the student to distinguish between military and civilian detention, although obviously we have to think about all those categories. The one thing I'll say is I think it's critical to keep in mind that part of why habeas matters, we pay a lot of lip service to habeas. The critical significance of habeas is in requiring the government to substantiate its case. Right? And so Scott talks about the Eisentrager decision from 1950. The thing about Eisentrager that a lot of contemporary commentators forget is that the German nationals, the 22 German nationals, conceded that they were detainable in Eisentrager. What they were contesting was their conviction by a military commission. Right? What makes the Guantanamo cases unique, what makes this whole body of law unique, is there is no precedent in either direction for the detention of suspected enemy soldiers during wartime who contested that they were in fact the enemy. Right? That is to say, there's no during World War II, members of the German army didn't contest that they were members of the German army. Right? And indeed, there were actually hundreds of cases where individuals in the US who were subject to detention under a statute called the Alien Enemy Act did contest whether they were in fact alien enemies, and the courts reviewed at least that question, what we call the jurisdictional fact question. So to me, there's actually an overlap between Scott's comments and Erwin's, which is that the reason why judicial review matters here is to avoid false positives, right? And then the harder fight is whether, even in cases where the government has made its case, should they be allowed to detain anyway. I think that's where reasonable people will always disagree.
So Scott's going to take
One
one
very
point
short.
on this before we move on to the next topic.
On Erwin's first point, in criticism of our current president, I want us to be clear, though, that President Obama did say he wanted to close Guantanamo Bay. I think were he here right now, he would say that is still his intent. What we must remember is it is not the president alone who has kept Guantanamo Bay open. The Congress of the United States, your representatives and mine, have consistently prohibited the use of any monies to close Guantanamo Bay. Many of you remember when, I forgot what the name of the town in Illinois was, where they wanted to create jobs by bringing all the Gitmo detainees there for this prison that was virtually empty. You remember that? The Congress of the United States said no funds appropriated by the Congress can be used to bring anyone at Guantanamo Bay into the United States for any purpose. So in effect, the Congress in the Authorization Act has gone further and said no money can be spent to build any facilities to move folks from Guantanamo Bay. So I think what we've got to look at is it is not just President Obama. It is our Congress that, for whatever reason, right or wrong, has decided that Guantanamo Bay will stay open. I take no policy decision on that. But Mario, are we moving on?
We are moving
on.
And so the next topic, which the conversation will be introduced by Professor Silliman, is a conversation about post 9/11, the use of civilian criminal courts versus military commissions to try suspected terrorists.
Yeah, I think almost everyone in this room probably remembers that a little over 2 years ago, the Attorney General of the United States basically announced in Washington that those at Guantanamo Bay, for which there is some evidence of criminality, and that's probably no more than 45 or 50 of those at Gitmo, would be prosecuted, some in our regular federal district courts, what we call Article III courts, and some in military commissions. And there was actually a matrix that the administration built up, and granted, very ambiguous. If you and I were sitting there, we could push a case either way, depending upon the factors. But then the big debate came about a gentleman by the name of Khalid Sheikh Mohammed. As you remember, the administration said he will be prosecuted in the federal courts, and there were really two different options. The Southern District of New York, which is where the World Trade Center was, and also the Eastern District of Virginia, which is where the Pentagon was. Either court would have jurisdiction. And that's the way it was going, and then everything came a cropper. Because Mayor Bloomberg said it's going to cost us millions of dollars for security on this. And then the Congress of the United States actually got involved, and as I mentioned before, started passing legislation that prohibited the use of any money available to the president to transport people into the United States for trial. So, in effect, as of right now, there is no way for the President of the United States to bring someone into trial, into the United States for trial in our federal courts, unless Congress relents. Now, there has been one trial, and it's a gentleman by the name of Giuliani. He had nothing to do with the attacks of 9/11. He was, in fact, indicted because of his involvement with the embassy attacks of 1998 in Kenya and Tanzania. Our U.S. embassies were bombed. Now, Giuliani was brought into the United States before Congress prohibited it by funding, and he was prosecuted in the Southern District of New York. The original charge had, I think, 283 counts, basically for everyone who died in those embassy attacks. The trial judge, Kaplan, actually ruled prior to the trial that one of the government's main witnesses, Al-Bibi, who supposedly sold Giuliani the explosives that were used, couldn't testify in the trial because his identity had been acquired through coercive interrogation. So the case went on. Giuliani was convicted, but of only one count, a conspiracy to bomb a building in which there was a loss of life. And people said, does that mean the trial in our federal courts doesn't work? Well, the trial judge gave him life in prison. So it's all dependent on how you look at that case. I will tell you right now, I am a firm believer that terrorists, alleged terrorists, can be successfully prosecuted in the courts of the United States if Congress is to relent. I firmly believe that. But I also firmly believe that military commissions are a viable option for some alleged terrorists, for security and other reasons. Now, let me just take a few of my moments of my time to tell you a little bit about military commissions. They're very, very controversial. And they're controversial because they're basically linked with Guantanamo Bay, which most people consider to be a stain on the United States. Military commissions have a rich history. Some of the very first trials in the United States before our Constitution were military commission trials. They were used most frequently in World War II. A famous case that we all teach, the Kieran case, involved a military commission. And as Steve said, the Johnson versus Eisenhower case emanated out of the military commission trial of those 21 Germans. But President Bush in 2001, on the 13th of November, based on the advice of his lawyers, but interestingly, no military lawyers were asked for their advice on this, created a system of military commissions by a military order that had a paucity of due process. And this is one thing that Erwin and I completely agree with. President Bush's first system of military commissions had no due process. And had the military lawyers been involved, it would have been a much better system and might have survived initial judicial review. But that system was struck down by the United States Supreme Court in the Hamdan case in 2006. And the court basically invited the Congress to get involved and legislate. And they did in 2006. And I, fortunate or not, testified before the Congress in 2 committees on that. And my argument was, if you're going to create a system of military commissions, use the Uniform Code of Military Justice as your model. That's the system that for the last 60 years we have used. Many of you who have served are recognizing that's the criminal law we use for our own servicemen and servicewomen. And it's inherently fair, very much like the trials in the federal courts. But the Congress in 2006 didn't do it. It did not outlaw the acquisition into evidence of statements that were procured not by torture, but by what we call cruel, inhuman, and degrading treatment. and it allowed in hearsay evidence. There were many other things that the 2006 Act did not do properly. There were 6 trials conducted under that Act. 2 of them are currently under review, the Bob Ewell and Hamdan case in the Court of Appeals for the District of Columbia Circuit. But more importantly, I will tell you that in 2009, Congress went back again under the Obama administration's request and changed the Act, and I think for the better. Now, no evidence obtained either by torture or cruel, inhuman, and degrading treatment can be admitted into evidence against the detainee. No matter what you hear, the statute does not allow that. Further, the statute allows that no evidence can go to a military jury, a military commission, unless the detainee himself has had access to and can challenge that evidence. So you might have heard in the press that classified evidence can be used against the detainee at Guantanamo Bay, and he'll never see it, nor his lawyers see it. That cannot happen under the 2009 statute. In my perspective, it is about 95% of where I would like it to be. 95% of what the Uniform Code of Military Justice provides for. But only history will be able to judge whether what we have done in creating the system and requiring now by Congress that trials be conducted at Guantanamo Bay by military commission, I think only history will judge whether it was the right thing for us to have done.
Could go to Erwin. First response.
Just a couple of things. First, Article 3 courts will have credibility that no military tribunal ever will have. When I speak of Article 3 courts, I'm referring here to the language of Article 3 of the Constitution that says that there will be a Supreme Court and such inferior courts as Congress from time to time shall ordain and establish, and that the judges of those courts shall have life tenure and salaries that can't be decreased. We refer to our federal district courts and federal court of appeals as Article 3 judges. The framers of the Constitution made that as a deliberate choice. They believed that by giving judges, the lower courts as well as just the Supreme Court, life tenure and salary protection, they would be immune from political pressure to the greatest extent possible, and also their rulings would have credibility to the greatest extent possible. I think a decision by an Article 3 federal district court will inherently have more credibility compared to a military commission. I think it is especially so given the history of military commissions in this country. Scott refers to the Quirin case in the early 1940s. That is hardly one of the better moments of United States history. What happened here was German saboteurs were caught in Florida. They were summarily brought before a military commission. They were sentenced to death. The Supreme Court affirmed this and then later released the opinion affirming it. And even the Supreme Court in subsequent decisions has referred to it as the questionable decision in Quirin. What Scott says with regard to the Bush executive order, promulgated not long after September 11th, is absolutely right. In fact, he may be generous in saying that it had a paucity of due process. As the Supreme Court said, it was clearly inconsistent with the Uniform Code of Military Justice and the Geneva Accords. Even though those defects in the military commission have been largely corrected, there is still a taint associated with the military commissions by virtue of this history. I think it's so important that whatever convictions there are for terrorist activity have credibility in the United States and in foreign countries. I don't think that that's going to be possible with military commissions, even if all of the procedural protections are the same. When I was at Duke, and this was being considered, the military commission was being considered, Scott made a point to me that was so powerful. He spoke to somebody who had served for a long time in the military, and I remember saying to me, how can the United States expect foreign countries to follow international law with the treatment of our prisoners if we don't follow international law with the treatment of foreign prisoners? Now, we've come much closer to that with regard to the 2009 amendments to the Military Commission Act, but I think we would be much better to have the credibility that would come from an Article 3 court. And the second point I want to make is that Article 3 courts can handle, and have shown they can handle, terrorism trials and other sensitive matters. Why is it that we want to take these out of the Article 3 courts? And I think for the Bush administration it was clear. They wanted to stack the deck. They thought they had a better chance of gaining convictions in military tribunals than in civilian Article 3 courts. But I think Article 3 courts have shown that they can handle such matters. Scott gives one example. Jose Padilla was ultimately tried in a federal district court, and he was sentenced to 18 and a half years in prison for material support for terrorist activity.
And the 11th Circuit vacated that as being too lenient.
Right. Which is, again, showing what the Article III courts can do. You might remember there was a plan to bomb Los Angeles Airport at the Sherman Williams, and just through a series of fortunate coincidences, it was uncovered, and Manuel Ressa was prosecuted in federal district court, and he was convicted. We can go back to the first World Trade Center bombing. There were convictions and sentences there. So I don't see what the need is to be able to go to something other than the Article III courts, and given the credibility inherent to an Article III court, I think it's much preferable.
Great, thanks. So just to sort of add a little bit of anecdote to Erwin's remarks, there was an op-ed, I don't know how many of you followed the Guantanamo cases, but I suspect some of you have heard of Casey Anthony. And there was an op-ed, I got one of those emails a couple days after Casey Anthony was acquitted, and the email was a headline. And the headline was, Casey Anthony acquittal proves why we need military commissions. And I assumed that this was from The Onion, right? That The Onion, being the clever journalism that it is, was having fun with me. Imagine my surprise when I click on the link and find that it's an op-ed written by Mitch McConnell, the Republican leader in the Senate. And so it begs the question, what Erwin raised, I want to sort of put it even more bluntly, what can military commissions do that Article III trials cannot do? Right? I mentioned before when talking about the detainees, that the question I always had about the NDAA was, why do we need it? Right? I think the question that has never been answered satisfactorily about military commissions is why Article III trials are insufficient. If you ask the judges who have presided over these high-profile terrorism cases, Scott mentioned the Gailani case. Gailani is the only one who was transferred from Guantanamo. But Zacharias Moussaoui was tried in Article III court. Richard Reed was tried in Article III court. Padilla, Almari, they were tried in Article III courts. Leone Brinkema, right, who presided over the Moussaoui trial, has said, yeah, it was a pain in the butt, but so are mob trials, right? We can handle these. And so I think the question is, what can military commissions do? Scott referred to the 2009 Military Commissions Act, and it is true that the Obama administration, to its credit, fought very hard to achieve structural reforms in the process in the military commission. So the 2009 Act increases the scope of appellate review of convictions, first in the court to which Scott was nominated, the Court of Military Commission Review, and then in the Federal Appeals Court in D.C. It increases the kinds of arguments that can be made by the lawyers. It takes out a lot of the sort of more trouble and constraints in the 2006 Act. But let me tell you one story that I think drives home the point about how much uncertainty still reigns. I was at Guantanamo in July 2010. Believe me, July is a great time to be in Cuba. I was there to observe the Omar Qatar proceedings. Qatar is a Canadian citizen who was tried for his involvement in the attack that killed a CIA agent, Johnny Spann. And the proceedings that I observed were about Qatar's attempt to fire his lawyers. Now, in American criminal procedure, there's something called FREDA, right? FREDA is the Supreme Court case that stands for the proposition that criminal defendants in the U.S. system have a qualified right to self-representation, right? That is to say, if you want to represent yourself, it's not a good idea, but if you're of sound mind and body, we'll let you. And that right comes from a combination of the Due Process Clause of the Fifth Amendment and the right to counsel in the Sixth Amendment. And this is called FREDA. The most recent case that the Supreme Court's had dealing with FREDA is a case called Edwards versus Indiana. You'll see why this matters in a second. So the lawyer, the appointed military lawyer for Omar Qatar, is up there trying to explain to the military judge exactly what Qatar wants, right? And the military lawyer, Colonel John Jackson, is trying to basically suggest that Qatar has a right to self-representation, and so long as he is of sound mind and body, so long as it's a knowing and intelligent waiver, he gets to fire his lawyers. And John Jackson then says, indeed, as the Supreme Court said in Edwards versus Indiana, and the military judge cuts him off and says, does the Sixth Amendment apply to these proceedings? Right? I mean, so as long as that question has not been answered, does the Sixth Amendment apply? I don't know how all the structural reforms in the universe can avoid the taint that Erwin referred to. right? Military commissions may actually be practicable. I suspect there are ways to create them that are lawful, that are constitutional. The problem is until you actually have smoothed over those fairly rough edges, you're always going to have that question, right? You're always going to have that uncertainty. And so long before you ever get to the legal question, you have the policy issue of why would you want convictions in such a system with so much uncertainty?
A brief rejoinder, I think. First of all, it's been talked about by both of my colleagues when we talk about El Mari or Moussaoui. They're properly convicted in Article III courts. Well, because they were in the United States. I would not stand here and say that you could take someone in the United States and ship them out of the United States for trial by military commission. And I don't think the administration has argued that. Matter of fact, I think all of us up here would say if someone is captured in the United States, they should be tried in our regular federal district courts. I don't think we'd have an argument up here. But remember, we're talking about a unique category of individuals who have never been in the United States. They are at Guantanamo Bay. And I'm sure I'll get an argument here. But the only thing the courts have said is that they are entitled to the right of habeas corpus. The court has not said that they are entitled to Fifth Amendment protections. The courts have not said that they're entitled to Sixth Amendment protections. That may be ruled on, but right now it has not been. So I am not trying to suggest to you that military commissions are the only type of trial that should be held for these people. I've written and I've said on many occasions, I think there is a usefulness to both forms. And the administration has to make that decision. But with regard to bringing the folks into Guantanamo Bay, even if Congress would allow them, there is an argument, and I'll defer to Erwin on this, he is my constitutional expert, that way back in a case in the 1990s, the late Chief Justice Rehnquist authored an opinion in Alvarez-Machin, in which he suggested that when you bring someone who has never been in the United States into the United States, that they somehow start to accrue, based on their circumstances, some measure of constitutional protection. The opinion is maddening because he gave us no examples. And the litigation following that case has been sparse. But this is something that was of concern, not just to the administration, but many members of Congress. That if you bring folks from Guantanamo Bay into the United States, if they didn't have constitutional protection under the Fifth Amendment before, they clearly have it when you bring them in. So that's more of a policy question that the government has dealt with. So we are dealing only with those at Guantanamo Bay who have never been in the United States. And I would suggest to you, if the administration ever thought about holding a military commission in the United States, we ought to boot them out of office, because then you're defeating the whole purpose of the use of a military commission. But again, please understand, I understand the criticisms. I understand that military commissions have been much criticized. But I think that we need to at least allow the decision makers to have a choice of forum to use in whatever case they feel appropriate.
So, Erwin, we will now turn to you to start the conversation on issues related to surveillance, wiretyping, and FISA, I guess, post 9/11 and contemporaneous. Oh, the God, my mind.
Foreign Surveillance Act. So, the Fourth Amendment of the Constitution, of course, says that there can't be searches or arrests without probable cause and warrant. The issue first came to the Supreme Court in the 1920s as to whether or not electronic eavesdropping is a search within the meaning of the Fourth Amendment. So the police generally would have to get a warrant, so they would generally need probable cause. In Olmstead versus United States, the Supreme Court said, so long as the police can do the electronic eavesdropping while entering somebody's premises, the Fourth Amendment wouldn't apply. So if the police could tap into somebody's phone by going into the phone lines outside, the Supreme Court said, well, that's not a search within the meaning of the Fourth Amendment. Justice Brandeis wrote an eloquent dissent. When I speak on these issues, I always like to quote it. He said, the greatest threat to liberty will come from people who act for beneficial purposes. He said, people born to freedom know to resist the tyranny of despots. He said, the insidious threat to liberty will come from well-meaning people of zeal with a little understanding of what the Constitution is about. To me, that frames so much of what we're talking about today. Olmstead was the law for several decades, until in the mid-1960s, the Supreme Court overturned it in a case called Katz versus United States. Katz involved a man who was making phone calls from a telephone booth, and the question is whether or not the Fourth Amendment required probable cause and a warrant. And the Supreme Court said yes. The Supreme Court said what the Fourth Amendment protects is our reasonable expectation of privacy. It doesn't matter whether the police enter our home or not. If they're interfering with, infringing our reasonable expectation of privacy, then there's a Fourth Amendment violation. Then the police need to be able to get a warrant, probable cause, under most circumstances. Congress responded almost immediately to that as part of the 1968 Onerous Crime Control Act. And Title III of it says that in order for the police to be able to engage in electronic eavesdropping, such as wiretapping, they need to have a warrant. There's to be probable cause of criminal activity. And this is the same as would be for any other search. And there's all sorts of requirements that are imposed in this law, such as a requirement for minimization. Minimization says if the police are listening, they should only listen to as much as they need to be sure that it really fits within the scope of the warrant. If not, they have to stop listening. Notwithstanding this law, the Nixon administration claimed that the president had inherent authority to engage in warrantless electronic eavesdropping. In other words, that the president could authorize warrantless electronic eavesdropping for the sake of domestic or national security and not need to get a warrant from any court. The Supreme Court considered that in 1972 in a case called the United States versus United States District Court. And the Supreme Court ruled unanimously that the president does not have the authority to engage in warrantless electronic eavesdropping for the sake of domestic security. One anecdote about that case. Arthur Knoy, who was a professor at Rutgers Law School, has developed what I think a very persuasive explanation that the Watergate burglary was really about this case coming down. What Knoy says is that the Nixon administration had been tipped off by the Supreme Court that this case was about to be decided, 8-0 against them. That the Watergate burglars were not actually going into the Democratic National Headquarters to plant bugs, but to get out the electronic eavesdropping equipment that they had put there. And he goes through and describes what tools they had with them that leads him to the conclusion that it was really this case about to be decided that led to the Watergate burglary and how much that changed American history. Pardon?
It was Forrest Gump.
There's a footnote in United States versus United States District Court, which is sometimes called the Keith case, where they left open the possibility of Congress creating a special court when it's a matter of gathering foreign intelligence information. The Carter administration, and especially then Attorney General Griffin Bell, fought very hard to have Congress adopt a statute enacted in 1978, which we were just referring to, the Foreign Intelligence Surveillance Act. It creates a special court, the Foreign Intelligence Surveillance Court. It was then comprised of 7 judges, all appointed by the Chief Justice of the United States. By the way, the now Chief Judge of the Foreign Intelligence Surveillance Court is John Bates, the judge who you referred to earlier. The Foreign Intelligence Surveillance Court meets in a secret room in the United States Department of Justice. It's allowed, under the terms of the law that was adopted in 1978, to authorize electronic eavesdropping if, quote, the primary purpose is gathering foreign intelligence information. And I'm going to come back to that language, but it was drafted in 1978 as part of the primary purpose being gathering foreign intelligence information. We know from many studies that the Foreign Intelligence Surveillance Court over time has granted over 99% of all of the requests from the government for so-called FISA warrants. And there are different interpretations of that statistic. Those who criticize the FISA court say any court that's doing what the government wants 99% of the time, actually more than 90% of the time, is not really serving as the check envisioned by the Fourth Amendment. On the other hand, those who defend the FISA court say that this shows the great care that the government takes in requesting FISA warrants. The FISA statute requires that the Attorney General of the United States approve it. And judges who have served on the FISA court say that the reason you have a statistic like this is that often, if the government's documentation is inadequate, they'll not deny it, but ask the government to go back and get more information. All of this changes, though, with September 11th, because in a profound way that we haven't discussed, I think 9/11 changes what we want law enforcement to do in this area. The traditional conception of law enforcement is that it's about detecting and solving crime, providing evidence to prosecutors that they can use for convictions, and that we hope that the criminal law overall will deter criminal activity. But after September 11th, we don't want the police just to be solving crimes after they've been committed and providing evidence to prosecutors. We want law enforcement to be there to prevent terrorist acts. We realize that the criminal law isn't going to serve as a deterrent. If somebody's going to be a suicide bomber, the possible sanction of the criminal justice system isn't going to deter illegal activity. And if we're going to prevent crime, we're going to prevent terrorist activity, then gathering information becomes key. Also, 9/11 shows us that no longer is foreign intelligence about, say, Russia or China spying on us, so those are still important issues. Foreign intelligence here is really directed more than anything else, bringing terrorist activity at Al-Qaeda, which isn't a nation at all. The Patriot Act, as everyone here knows, gets adopted very quickly after 9/11. It's an enormous statute with many provisions. Some are not controversial at all. Some are deeply troubling. Many deal with what we're talking about now, intelligence gathering. One of the key changes that the Patriot Act makes to FISA is it says that a significant purpose has to be foreign intelligence gathering. No longer does it have to be the purpose. Now, the change from the to a may not seem to matter all that much, but practically speaking, it matters a great deal in terms of whether or not there can be a FISA warrant. There's other things in this. It authorizes roving wiretaps. It authorizes sneak and peek warrants. It expands the ability of the police to use so-called traps and traces, monitoring phone calls, numbers that people call without having to get a warrant. And then there's subsequent amendments. For example, there was concern about what about the so-called lone wolf terrorist? And FISA gets changed to be able to expand beyond just terrorist groups to the so-called lone wolf terrorists. Are these changes constitutional? We don't know. There's no Supreme Court decision yet as to whether or not information gained through a FISA warrant is admissible in court. It's amazing, given that FISA is not new, or even the Patriot Act isn't new, that there hasn't yet been a Supreme Court decision considering, well, is a warrant that's based on a significant purpose enough to meet the requirements of the Fourth Amendment? If somebody has a FISA warrant issued against them, and the evidence is then used in court, they can, in court, challenge the admissibility under the Fourth Amendment. However, they are not allowed to see the FISA warrant that was issued. That makes the legal challenge difficult. As I said, there have been no Fourth Amendment cases on this to the Supreme Court yet. Let me just add one more thing to this before turning it to the panelists. One provision of the FISA Act says that all electronic eavesdropping has to be done either pursuant to the 1968 Omnibus Crime Control Act provision or under the FISA statute. And the law is quite specific in saying if the police are engaged in electronic eavesdropping, it has to be either by going to a federal district court under the 1968 law or going to the FISA court under the FISA statute. We learned in 2005, thanks to New York Times, that the Bush administration, the terrorist surveillance program, had authorized the National Security Administration, the Security Agency, NSA, to engage in what seems to have been massive, warrantless electronic eavesdropping. The NSA was engaged in electronic eavesdropping of conversations between people in the United States and those in foreign countries where there was suspicion of terrorist activity. We know now that the New York Times learned of this in 2004, that the Bush administration asked them not to reveal it. For a year, the New York Times sat on this and did not disclose it. We know that when the New York Times said that they were going to publish it, President Bush went to the publisher of the New York Times and said, you will, quote, have blood on your hands if you disclose this. The New York Times went and disclosed it anyway. Okay. I remember being in your office, Scott, when this came out and having discussions about this. President Bush claimed that he had the inherent authority as president to engage in warrantless electronic eavesdropping for the sake of national security, and that it did not need to follow the statutory provisions of either the 1968 Act or FISA, and did not need to get a warrant under the Fourth Amendment. A lawsuit was brought. It was titled ACLU versus National Security Agency. It was brought by individuals in the United States who regularly had communication with those in foreign countries, and they claimed that their conversations were being chilled. The District Court, Michigan, ruled in favor of the ACLU. The Sixth Circuit, in a 2-to-1 decision, said none of the plaintiffs can show that their conversations were intercepted. So since they can't show that their conversations were intercepted, since the NSA doesn't tell, they don't have standing to be able to sue. There have been some other lawsuits, most recently in the Second Circuit, that can be a basis for challenging this. So there's still some possibility that it will get to the Supreme Court. But this is a whole separate issue. Because of public pressure, congressional pressure, ultimately the Bush administration said it was ending the terrorist surveillance program. But if you read very closely the statements of Alberto Gonzales at the time, he left open the possibility there was a lot more going on than's ever been revealed.
Very quickly, this court that Erwin has talked about, there's now 11 judges that sit individually. They don't sit en banc or as a court. And by the way, it's now in the district court, the District of Columbia building in Royce Lambert's court. But something you need to understand when Erwin talks about the tremendous figures of approval by the justices, the judges on this court. The statute is very unusual. And the statute says that if that judge determines that the requirements of the statute are met, the judge shall approve the surveillance. It forces the judge to do it. And I have looked at it, I haven't talked with Erwin, I think that that's a reason for a lot of the figures being so high, simply because the Justice Department folks who work up these applications sometimes come in with 70, 80, or 90 pages just to make sure that they get all the dots in the right place so they can get approval. Now, the other thing that I want to mention is take it where Erwin left off. Because after President Bush suspended, we think, his terrorist surveillance program, then an unusual thing happened. That a judge on the court, the Foreign Intelligence Surveillance Court, we believe ruled that communications that were emanating in one country, say France, to another country overseas, say Germany, which had never been regulated before, which were routinely intercepted, that because those communications, the technology of today sent them through an electronic switch in the United States, and because, as Erwin suggested, any interception of communications in the United States had to go through that Foreign Intelligence Surveillance Court, that this immediately slowed down all the applications and the surveillance. So the administration immediately went to Congress, and Congress passed first what's called the 2007 Protect America Act, which lapsed. But now the most current iteration of the law is what we call the Foreign Intelligence Surveillance Act, Amendments Act of 2008. Terrible name for all. But what it does is extremely significant. It says that if the Attorney General and the Director of National Security, that's Eric Holder and General Clapper, reasonably believe that the target of the interception is outside the United States, they need not go individually to the court, that they can approve that surveillance. Now, the other striking feature of this new statute is the old law, the 78 law, said that in order to justify surveillance in the United States, you had to show that the individual was a foreign power, an agent of a foreign power, or as Erwin said, a lone wolf. That's the Moussaoui exception, unaffiliated terrorist. The new legislation does not require that. A perfectly innocent person overseas can now be the target of electronic surveillance. Now, there is a provision for what we call reverse targeting, which means if you're an American citizen, The United States cannot surveil you, even if you're overseas, without going through this Foreign Intelligence Surveillance Court. But the big debate right now in Washington is that if a person overseas who is the target, who may not be a United States citizen, is talking to you or to me at the other end of the line in the United States, there is no protection. There is no protection. So the question that I have been dealing with is, even this most current status of the law, is it really something that we want to live with? It solves a problem, but does it fully protect you and me as American citizens? Or does Congress need to go back and take another hack at it? What they've done ever since 1978 is what I call a Band-Aid approach. They have taken a law that was passed in 1978 when we were still using corded telephones, and they have tried to apply it to Skype and all the other sorts of new communications. And I would suggest to you very respectfully that Congress doesn't really know about technology. So, should we scrap the whole 1978 and start all over again with a well-reasoned application of constitutional protection, or should we continue to Band-Aid it? And this is something that the Congress of the United States needs to take a look at, in my humble opinion.
Steve? Great, thanks. I'm often asked by my students and by others if I can provide a capsule summary of how in the 10 years since 9/11 their rights have been affected. And my first response is to tell them why that's not the right question, right? That we don't have rights for the sole purpose of protecting ourselves. That said, I usually find that to be an insufficient answer for their purposes. And I think it's safe to say that the first two things we've been talking about on this panel are probably things that we've just met, but I'm assuming most of us will never encounter, right? That is to say, military detention as a terrorism suspect and/or military commission prosecution as a terrorism suspect. What makes to me the FISA wiretapping issue so much more salient is the odds that this will affect us, whether we know it or not, are substantially greater. Right? The odds that communications in which we're involved will be swept up either through a FISA warrant or otherwise through one of these mediums is far greater than that any of us are going to end up at Guantanamo, except by volunteering. And I think it's important to keep that in mind as we're talking about this. Now, Scott rightly says, right, that the revised FISA, the FISA Amendments Act, doesn't allow for the targeting of U.S. citizens overseas. The problem is overbreadth, right? The problem is that the government is sweeping in so many communications through the wiretapping that FISA authorizes that it's just statistics that conversations of American persons that are not otherwise directly authorized to be intercepted will be intercepted. Normally, right, the way that we work that out in our criminal justice system is through the adversarial process, right? So it's true that what Erwin referred to as Title III warrants, the warrants we see on Law and Order, right? Although Law and Order, the warrants are thrown out a lot more often than they are in real life, so otherwise Law and Order wouldn't be entertaining. But the warrants that we see in real life don't have an adversarial process either, except that those cases go to trial, right? And that oftentimes the evidence, the propriety of the warrant is litigated at trial. The problem, as Erwin points out, is there have not been trials in the Article III court since 9/11 that have turned on FISA evidence. There haven't been trials since the USA Patriot Act relaxed the primary purpose rule. There haven't been trials since the FISA Amendments Act changed the rules again. Without trials, right, there's no opportunity to develop what the rules are. And so Scott may be right that there are structural reasons why the government wins so often in the FISA court, but without any prospect of judicial review down the road, I think it's that much more of a reason why this process is tilted toward the government. One last point before I sort of shut up. Scott and Erwin both talked about the FISA court, the Foreign Intelligence Surveillance Court. Well, we're lawyers. We create more courts. So above the FISA court, there's actually a court called the Foreign Intelligence Surveillance Court of Review. Now, those of you who are lawyers, you know what the Blue Book is. Try Blue Booking the FISA Court of Review. It's a pain in the butt. The FISA Court of Review has issued 2 decisions in its history. Right? The first was in 2003 when it reversed the FISA court's ruling. 2002, forgive me. When it reversed the FISA court's ruling that had required the government to show more evidence under the USA Patriot Act. The second was under the Protect America Act in 2008. Why do I mention all of this? Well, in this case, which is called, it has a really long case name. Let's just call it In Re Directives. I think it's In Re Directives, Redacted, issued pursuant to Section 105. Anyway, what the FISA Court of Review said, for the very first time, it recognized that there is something called a foreign intelligence surveillance exception to the warrant clause of the Fourth Amendment. Right? So before this decision in 2008, this had all been litigated at the statutory level. Right? The question was, what did FISA authorize? Had President Bush, for example, violated FISA through the wiretapping program? Now, for the first time, we have a constitutional decision that holds that you don't actually have to have a warrant, even though the Fourth Amendment has a warrant clause. That you don't have to comply with the rest of the Fourth Amendment in cases where what you are doing is foreign intelligence surveillance. Now, that's only the FISA Court of Review. It's not the Supreme Court. As everyone said, this issue still hasn't gone to the Supreme Court. But if we're making a list of long-term rules that have come out of the last decade that could end up seeping into our ordinary criminal justice system in ways that we actually might see far quicker than we'll ever see the wrong side of a military commission, that to me is a big one, right? Because then the question is, even if the government makes a mistake and accidentally intercepts your communication, let's say you're just talking about a plot to defraud your, I don't know, your friends, right? As long as the original purpose of the FISA wiretap was the procurement of foreign intelligence surveillance, the rest of the Fourth Amendment's not going to apply, right? And that to me is a rather alarming development and a way where all the law that we think is limited to national security and counterterrorism could easily seep into ordinary criminal law enforcement.
One of the reasons there is not that many court cases is that under the FISA statute, only the government can appeal. Matter of fact, in one of the cases that we talked about, the ACLU actually tried to intervene and take a case to the United States Supreme Court. The Supreme Court says you're not a proper party and dismiss. So unless the government appeals, and with the statistics that Erwin gave us, why would the government appeal?
They've appealed twice, and they won both appeals.
They did.
Winning. So we are now at the point that we have set aside for questions from you. And to the extent that there's at least one other topic we might have wanted to get to, I encourage panelists, where it's relevant, to include those comments and responses to questions, remembering where it's relevant.
What isn't relevant?
Yes, sir. Yes, sir.
You know, first of all, I would just commend the speakers. I don't think we could have had a more brilliant exposition of the jurisprudence that we're examining, so I thank you for that. And I hasten to add that, you know, I think it's something both very noble, and I also think it's historically stupid, that American public generally and lawyers have this kind of pervasive presupposition that it's an inherently positive thing for us to extend American constitutional law to non-citizens, and to non-citizens who are in a foreign place. And I think that it's historically really anomalous and misguided. And in that sense, I think the most, you know, when you guys were talking about the law, you were all unsurpassed, but every time you ventured into your, you know, sort of editorializing, you betrayed a pretty consistent bias. When President Bush is doing something that we find to be excessive, and I'm not here to defend President Bush, but then suddenly, you know, it's all on him. But when President Obama is doing something that maybe we question, he's got to deal with Congress. But the fact of the matter is that President Obama, the first 2 years of his administration, had a Democratic-controlled Congress. And if they had wanted to correct any of these things that you're talking about, they had all the opportunity in the world to do it, and they didn't do it. There's a reason why they didn't do it, and that is because they know that in the end, Article III courts are not going to be able, they may be able to deal with a lot of these prosecutions, including the U.S. citizens and the people apprehended in the United States. But there are situations within contemplation that everybody knows an Article III court isn't going to be able to deal with. I think it's also interesting that everybody talks about the paucity of due process, but somehow or another, it's okay to assassinate Osama bin Laden. Somehow or another, it's okay to, instead of, everybody's all offended about waterboarding, but it's okay to send in the drones. And so I'm saying I detect in some of the editorial comments a double standard. Let's demonize Bush and let's apologize for Obama. I think the most intellectually honest statement I heard in the context of editorial comments was the dean's comment, which is that if you accept the proposition that American standards of justice that we provide in our courts to U.S. citizens who have their rights under the Constitution, should be extended to non-citizens who are enemy combatants, then President Obama is as much of an offender as President Bush was. And I would add that I think it's a case of historical amnesia that we forget that President Bush, and again, I'm not here to defend President Bush, I'm here to talk about intellectual honesty and a double standard here. If you want to talk about the violation and abuser of rights in this area that we're talking about, President Bush at his worst, waterboarding, surveillance, at his worst, was a walk in the park compared to what FDR did to the Japanese. He put them in concentration camps based on the color of their skin, took their property away from them, and held them without habeas corpus, and they never got, they never had anything resembling what we call justice. But with that as a predicate, what I'd like to ask is a question about Boumediene.
No, very professorial.
I'm worried about your question.
My question is this. Justice Kennedy's opinion in Boumediene starts with a rather tortured and, to me, bizarre discussion of the insular cases. And he talks about the history of the Spanish-American War and the Treaty of Cession and the insular cases, Downs v. Bidwell in 1902, and then he goes to the Balzac case in 1922, which extended the colonial regime that existed under the insular cases to U.S. citizens once citizenship was granted in Puerto Rico. And what he does is he hides behind the insular cases intellectually to say that we're going to do the same thing with respect to habeas corpus for these detainees that we did in the insular cases. We're going to adopt a jurisprudence by analogy. In the insular cases, what they said is the Constitution doesn't apply to the U.S. citizens of the territories. So we're going to give them something called fundamental rights, which is undefined and yet to be determined. And my question is this: what I heard both of you all say was that the Boumediene case applies the Constitution and applies the habeas corpus provisions directly to these people. And if that's the case, I'd like you to confirm that that's how you read the case, because what I read in the case is that they sort of did the same thing that the insular cases did. By analogy, they said, these people don't have the right to habeas corpus, but the Constitution requires us to give them something in the way of protections and due process. So what we're going to rule is that what Congress gave them in the statute isn't enough, and Congress has to go back and by statute do more for these people. But I think my question to you is it your position that the Boumediene case says that non-citizens who are arrested on the field of battle have the same right to habeas corpus that U.S. citizens have who are taken into custody domestically here in the United States?
Let me guess. Is there anybody who wants
Well,
to?
yeah.
We'll start with you.
Your question is, how do we interpret the Boumediene case? I do interpret it as Justice Kennedy writing for the court, extending suspension clause coverage to those at Guantanamo Bay. Nowhere else. He didn't say it extended anywhere else. Now, I was a bit disappointed in the opinion, because many of us looking at Justice Kennedy's prior opinions in Razul hinted that what he wanted to do, if he got 4 other votes, was to grant habeas. If he was going to do that, I would have wanted him to deal with Johnson versus Eisentrager frontally and overrule it. He did not. He distinguished it. So that is disappointing to me. But I have to read the opinion as being a grant of habeas. Whether we like it or not, he did it, and at least...
That's the application of the Constitution?
Well, the habeas cases in the district court for the District of Columbia, who have these cases on remand, have basically been honoring the habeas petitions, and so they are interpreting it. And even Chief Judge Sintel, in the circuit court opinions, has recognized that when they apply the 3, what we call the 3 Boumediene factors, that it extends habeas. Now, I think when you talk about
Statutory
Kennedy...
habeas, statutory habeas?
No, constitutional habeas. Constitutional habeas. I mean, Razul gave him statutory habeas. Congress did it. Congress can overrule a statutory opinion. This is a constitutional habeas. Now, rightly or wrongly, that's the status of the law, and why I think I said in my comments, it's a huge, significant case when the Supreme Court did that. Now, let me just address one other thing, and I'll turn it over to my colleagues. When you talk about unfairness to President Bush, my comments with regard to the Bush administration were to the paucity of the military commission system under the president's system, and my criticism was that he did not consult military attorneys to ask him to draft it. Because you're talking about military commissions, and military lawyers are the ones that deal in military law. The judge advocate generals did not find out about that military order until after it was issued. That is ludicrous. That was my criticism, not of the president.
Taking moderator's privilege before we move on, and just to add support to something Scott said, as somebody who was an active duty judge advocate at the time, who our duty is to follow our commander-in-chief, our surprise, and was working on terrorism cases at the time, was in the notion of the lack of consultation, especially where the accusation would be that we had gamed the system to create the zone of lawlessness around Guantanamo, and then secondarily, when we got the memo start coming down, what seemed to be both a lack of process, but also a reliance on ex parte querying, where we knew, given that it had often been referred to as a low watermark in Supreme Court jurisprudence,
Not the court's defining power.
Yes, that there was going to be significant pushback. And so there was, and in talking with the Judge Advocate General of the Navy at the time, there was a concern that had there been consultation, there would have been advice given that could have reached, perhaps at the time, a better arrangement. And so that's...
What they did was they took Roosevelt's proclamation in the Curing case, and they copied it. They copied it. Paragraph 7 of President Bush's order is virtually identical to President Roosevelt's order, which suspended habeas, said it couldn't be habeas, and the Supreme Court, when it at least took the Curing case, invalidated it. I remember being in Washington.
Wait, are you saying the Supreme Court in Kieran specifically said that enemy combatants charged with crimes trialed by a military commission could bring a habeas petition even though they weren't citizens and they weren't lawfully in the United States?
No. No. I think all of us teach the Kieran opinion is probably one of the most controversial opinions that Chief Justice Stone ever wrote. What I'm saying is the Bush administration relied on that.
Absolutely.
And relied on it. Now, again, as Mario said, military attorneys were well aware of what needed to be done, but were shut out of the process. It was written in the White House General Counsel's office. And I don't want to be critically personalizing anyone, but if you're going to create a massive program, go to the people who know what they're doing to do it, and that's my only criticism.
Can I make 3 quick points, and then Erwin can sort of explain better than I can. So the first point, Justice Kennedy literally says, this is a quote from his opinion, the suspension clause has full effect at Guantanamo. If that's not a constitutional holding, I don't know what is. And I think, whether we like it or not, I think there's no dispute that it's actually grounded in the text of the Constitution. I will say, I think it's a bit misleading to refer to the Japanese-American internment cases. They did get judicial review. They got habeas. I mean, you wouldn't have the much maligned Korematsu decision if there had been no judicial review. Many of you probably heard of Korematsu. The case you probably have not heard of is the case decided the same day as Korematsu titled Ex Parte Endo, which was a habeas petition. Now, I'm not going to defend the internment camps, but I think it's a far cry to say that there was no judicial review there, when in fact it was the prospect, it was the specter of the Korematsu and Endo decisions that led the Roosevelt administration to shut down the internment camps in December of 1944. Last point, I think you suggested in your comments that we're drawing a sharp line between President Obama and President Bush. I didn't say anything about target killing or the Osama bin Laden operation. I think there were serious questions about them. I'll also say that I think there's a very big difference between the permissible use of military force on the battlefield and the abuse of prisoners once they're in custody. I don't think that the lesser includes I don't think that the greater necessarily includes the lesser in that case. I think they're two totally different conversations. But I will say this, I think there's an enormous distinction to be drawn, not between President Bush and President Obama, but between the first 5 years of the war on terrorism and the last 6. So from 2001 to 2006, the Bush administration's approach was unilateralism. right, was arguments about executive power, was arguments about why, even though Congress had constricted their authority in the FISA statute that Erwin mentioned, in the U.S. Citizen Non-Detention Act, in the anti-torture statute, why those statutes were all unconstitutional, why the executive had preclusive Article II power. What changed in 2006, before President Obama was ever, anything more than the junior senator from Illinois, was that Congress got involved, right? And I think that's when the conversation changed. That's when the litigation changed. No longer was the claim, as it was in Hamdan, President Bush is acting unilaterally in a way that's unlawful. Now the claim was the government as an undivided whole is acting in ways that are unlawful. That was the claim in Boumediene. That is the claim at the heart of most of the lawsuits today challenging the Obama administration. So I don't think it's Bush versus Obama. I think it's unilateral use of presidential power versus proper structural use of the separation of powers.
I actually going to disagree a little bit. 3 points. I'll be very quick so we can get other questions. The first is my central point is that the government has to follow some law when it's dealing with human beings. If it's not the United States Constitution, then it has to be the Geneva Accords and international law. And where I'm most critical of the Bush administration was its position that could hold people in Guantanamo, or even American citizens of the United States, without having to follow any law whatsoever, and without being subjected to judicial review. Second, I do think there's a difference between the Obama administration and the Bush administration. Here I will disagree. I will be very critical of a great deal that the Obama administration has done in this area. I've already criticized not closing Guantanamo, but I accept, of course, what Scott says, that there's many reasons, including federal statutes. I've criticized every time the Obama administration's invocation of the state secrets doctrine. I've criticized how the Obama administration, just here in Orange County, went to the federal court and said they could lie to a federal judge and not complying with a Freedom of Nation Act request. And I'd certainly criticized some of the targeted killings. That said, I think that the violations of the Constitution and national law under the Bush administration were far worse. So far as we know, no other president in history systematically adopted and implemented a policy of torture of human beings. And when you read Jane Mayer's book, The Dark Side, or the Red Cross report, that's exactly what the Bush administration did. When we talk about the terrorist surveillance program, massive electronic eavesdropping in violation of the Constitution. And we can go on with other examples. Well, you may be right that what Bush did isn't as bad as what Roosevelt did to the Japanese, but that doesn't justify other violations of rights. Finally, in terms of the Boumediene case, the Insular case, I believe, are one of the embarrassments of American history. And just so everybody knows, after the Spanish-American War, the question was, what's the status of Puerto Rico, Philippines, Guam? In the Insular cases, a series of Supreme Court cases basically said the United States could be a permanent colonial power. And that's what they've made us for places like Puerto Rico, Virgin Islands, Guam, American Samoa, the Northern Marianas Islands. I don't think that they're playing a key role in Boumediene. I think that it's Justice Kennedy, as he's wont to do, tracing a lot of history before getting to the point. But I think here Steve is absolutely right. The Supreme Court said that habeas corpus applies to those in Guantanamo, and that the Military Commission Act is a suspension of the right to habeas corpus, so it violates Article 1, Section 9 of the Constitution. You asked the question, does Boumediene say that a non-citizen caught in the field of battle has the same right to habeas corpus as an American citizen of the United States? No, the court doesn't do that. What the court does say is, at least to those held in Guantanamo, they have to have access to federal courts via writ of habeas corpus. Beyond that, we don't know what it means.
Other questions? Yes, sir.
This is from a rank outsider, so please bear with me on this. First, just a little observation that given that there are so many members of Congress and the executive branch who are lawyers, I find it amazing that they've screwed it up as much as they have.
Or not surprising at all.
And also, I have to say I've been very confused by all of the things that have gone on. I've merely been a reader of it, and it's been a wonderful evening to hear, expedited as well as it has. But the thing that, the threads that seem to have run through the presentations this evening have been the war on terror and the declaration of war. And that, particularly with the first speaker, with the MDA, I didn't follow all of the specifics of that. And so my question is a declaration of war, does it need to be a formal declaration of war? And if so, does the declaration of war have to be against a sovereign country? Because if it does, then I have to really question a lot of the other stuff that goes on in this whole context.
Steve, we'll start with you.
This gives me a chance to ask my favorite constitutional law trivia question. Does anyone know the last country the United States declared war against?
Mexico?
Not Mexico. A little more recent than Mexico. Romania. Just in case you lost track of that. The last country we declared war against was Romania in 1942 as part of World War II. So the short answer is we don't declare war anymore. And there's a complicated series of reasons why we don't formally declare war, much of which have to do with the ban on aggression, right, under international law. Well, no, right. So that's the irony of all this. So it's not what Congress did in 2001 was not declare war. They used the phraseology that Congress always uses now, which is they authorized the use of military force. So that's how the first Iraq War began in 1991. That's how the second Iraq War began in 2002, 2003. That's how we do it these days. Now the question is, what is the difference between an authorization for the use of military force and a declaration of war? So far, there have actually been a series of differences. So there are a number of statutes that refer to time of war. For example, tolling statutes of limitations when you can bring a lawsuit, for benefits purposes, for who can be tried in particular kinds of courts. The courts have generally held that in time of war means time of declared war, right? And so when force is authorized under a non-declaration of war, those statutes aren't triggered. The flip side, though, is, well, wait a second, if we're not declaring war, how can it be war? Right? How can the president rely on all of his war powers? And that's where the Hamdi decision, I think, is actually very significant in the government's favor. Right? Even though the Bush administration lost that case 8-1 on the process question, the one thing that the administration won there was the recognition that the AUMF validly triggered the president's war powers, whatever they may be, and that the argument that this just isn't a war basically went out the window. Now, one last point before I sort of leave it to the others. There's a common phrase that Congress declared war on terrorism, right? I actually think this is an unhelpful meme, because the reality is Congress actually had more specific criteria in the AUMF. It was only groups who were directly related to the 9/11 attacks, right? So, for example, the AUMF does not authorize the use of force against Hamas, or against the Kurdistan Workers' Party, or against other terrorist groups unaffiliated with 9/11. One of the more dangerous things that the NDAA, the National Defense Authorization Act, does is it starts moving away from the tie to 9/11. Right? It starts to fine and detention authority less by reference to that particular group's involvement in the 9/11 attacks themselves, and more their general involvement with Al-Qaeda and other groups that were they responsible for the 9/11 attacks. So I actually think it's unhelpful to think that Congress generally declared war on terrorism. Part of why the NDA is so dangerous is because arguably it comes closer to doing that than Congress has ever done before. And I think that's a bad thing.
One thing to add is besides even an authorization, a formal authorization like you had in Vietnam, the Gulf of Tonkin resolution and the AUMF, the courts have held that even if Congress appropriates money in support of a military operation, that legitimizes it constitutionally. So you don't have to have a declaration of war clause. You don't necessarily need a formal authorization as long as Congress participates. That's what the Vietnam cases have told us. But also, even if you don't have that, the big ongoing debate is how much authority does the president have as commander-in-chief? Because nowadays, no president will try to use force unless he can cabinet in a concept of self-defense. Because you don't need anyone's permission as long as you're responding in self-defense, whether you're talking internationally or under the traditional understanding of the Constitution. Erwin, over to you.
There's a second question. You're absolutely right that one question is what's the scope of the president powers commander-in-chief, but there's a second question of what's the scope of authority under an authorization for the use of military force? How long does it last? The Joint Authorization for Use of Military Force was adopted in 2001. Does it continue forever? Is there a point at which it's no longer operative? What does it authorize? What Steve points out is in Hamdi, the Supreme Court said in a 5-4 decision, and 4 of the justices clearly said this in the majority, and the 5th went along, that the Joint Resolution for Military Force authorizes detention of American citizens as enemy combatants, though they have to be given due process. But when the Bush administration engaged in the warrantless electronic eavesdropping, they tried to argue that the Joint Resolution for Military Force authorized that. When they created the military tribunals in the Hamden case, they tried to argue that the Joint Resolution of Military Force authorized that. So how far does an authorization for military force extend in terms of what it permits the president, and for how long? And I think that's also an open and important question.
One of the difficult things, very quickly, is in that case that we talked about, the Hamdi case, Justice Senator O'Connor's opinion, she basically said, even as to American captured on the field of battle in Afghanistan, he's not entitled to full due process. What she said was, he's entitled to challenge his detention, he's entitled to notice of charges, challenge his detention before a neutral decision maker. And in a citation, she said that could even be a military tribunal. Now, she wasn't talking about a military commission. She was talking about what we call an Article 5 tribunal under the Geneva Conventions. Well, guess what the Department of Defense did 10 days later? They created these combatant status review tribunals at Guantanamo Bay that were modeled on exactly what Justice O'Connor said. And then the irony is, in the Boumediene case, the Supreme Court, 4 years later, said, hey, guess what? That's not good enough.
Although Scott says it's ironic, I think it's important to keep in mind a very important distinction. Justice O'Connor, in her opinion in Hamdi, was talking about a U.S. citizen captured on the battlefield in Afghanistan in the context of active combat operations. And if you read her opinion, you'll see the number of times she refers to the specific facts underlying the holding. The detainees at Guantanamo, many of them were captured on the battlefield in Afghanistan, many of them were not. Some were captured in Macedonia. Some were captured in North Africa, right? One or two were actually captured in Western Europe. So, I think we have to be careful. I know it's hard to sort of keep up with all the distinctions we've been adverting to in our remarks so far tonight, right? But I think actually here it matters quite a lot, because I think we might all say, forget the law for a second. As a matter of policy, I'm a lot more comfortable when you have someone who our soldiers picked up shooting a gun at them on a battlefield in Afghanistan, giving them less process, having it be before a military judge, versus an individual who's picked up by a foreign intelligence service off the streets of a Western European city and turned over to us without any judicial review. Right? To me, those are two very different cases, and one of the mistakes I think we've made over the past decade is treating them of a piece simply because the government, whether it's the Bush administration or the Obama administration, points at them and says they're the same people.
And we've been very patient.
I'm wondering whether there is any legal justification for assassinating such people as Osama bin Laden. It troubled me, and I find the answer I'm getting from normal people among our citizens is it's really expedient to do that, to assassinate them.
You can start, Steve.
So I'm going to make this argument not because I agree with it, but because I think it needs to be made. The argument for the operation, which I think the government would never call an assassination for various legal reasons, is the AUMF authorizes the use of military force against Al-Qaeda and other forces, right? So presumably, if we found Osama bin Laden on a battlefield in Afghanistan, we could pick him up, right? If we found Osama bin Laden on a battlefield in Afghanistan holding a gun and pointing at one of our soldiers, I suspect we would all agree the soldier can fire back, right, and will not face prosecution. Instead, he'll have what we call combat immunity under the laws of war. Right, and so I think the legal argument for the Osama bin Laden operation is that this was not that far removed. Right, special forces wearing the U.S. Insignia helicoptered into a compound in Pakistan, not that far from the battleground in Afghanistan. Right, they were engaged in hostilities. They were firing weapons. They were under fire. Right, and in the process, Osama bin Laden was killed. Now, I think that's the argument. Of course, the response is that's not the narrative that certain people have reported, right? Of course, the response is, well, wait a second, what if he tried to surrender and they killed him? That would be a crime, right? That would be denying quarter, which is not only a war crime, but is triable by a military commission under the Military Commissions Act of 2006. So, I don't want to suggest that this is the right answer, but I think that's the way the argument proceeds, right? That this is part of the military force Congress has authorized, and sending special forces into a compound in Pakistan is not as far removed from the traditional battlefield engagement in Afghanistan as you might like to think.
The key is the administration's argument that we are in a state of armed conflict with Al-Qaeda. That's the predicate. Because if that is true, and I have to say that I teach in Europe every summer, and they say, you're an idiot, you say. It's a crime. Terrorism is a crime. But if that's true, as the United States argues, then under the law of war, then if an individual is a combatant, lawful or unlawful, in armed conflict, you don't have to arrest them first. You can kill them. Now, the problem is, what are the dimensions of that? How far does the armed conflict extend? Does it extend right here in California if you're dealing with a member of Al-Qaeda? No one really wants to talk about how far the law can be extended.
They
But
come here and start killing our soldiers for what went on in Iraq? Or?
well, the problem is, again, under the administration's predicate argument that we are in a state of armed conflict, which is buttressed by the AUMF, then we, the administration, argue, not that I'm a part of it, that we have the right to kill. And that was what was problematic, is that people said, well, if he had tried to surrender, and they're here, what were the facts? Did he try to surrender or did he not try to surrender? That's fact-based. If he did, as Mario said, then he no longer could be killed. He must be captured if he was trying to surrender. The administration argues that he was not, that he was still a risk and could be killed. I don't want to try to judge one way or the other, but to try to explain it, you've got to understand why the United States believes that we are in a state of armed conflict and why the law of war applies rather than human rights law, which says you must try to capture someone first.
I must pursue that by saying, does that give them the right then to come here and assassinate, kill in a conflict our generals, our leaders,
Well,
Right is such a peculiar term in that.
I mean, I'm not suggesting I want them to do it, I'm just curious. I'm not really curious about the way America thinks.
Yeah, one of these, I'm going to agree with Scott and Steve in one way and then I think disagree in another. The way I want to agree is we really don't know what happened that night. And not knowing what happened makes it very difficult for us to assess. If this was a battlefield and bin Laden was firing, there's no doubt we could fire back and kill him. On the other hand, if he's sleeping in a house, to then go and kill him, I think even if he is in battle, I think does violate international law. I think that...
But that would be inconsistent with rules of engagement unless...
Not the law.
No,
The rules of
engagement for the government or for forces unless, well, this gets into a different conversation, he presented a danger to those
Right,
forces.
that's it. Once he poses a danger to our forces, and that was the argument the Obama administration made at the time, then we are allowed to kill him rather than capture him. Goes back to what I said at the beginning. We don't know what happened that night.
Right, but I would disagree with you on what you believe the international law is. The international law of war would say if an individual is a combatant, he or she can be killed regardless, unless they take themselves out of the battle and become
or surrender.
Yeah,
Right, because they're already declared
And again,
hostile.
we don't know what happened that night.
Because
but if he was sleeping, I maintain that under international law of war, he could be killed.
Let me just make a more general point. Because we don't know what happened, I think it's helpful to sort of think about this as a more general. The question you raise is the reciprocity problem, right? And I mentioned the Omar Qatar case, right? One of the Omar Qatar's defense when he was charged before a military commission with being involved in the attack.
Of course, he pleaded guilty in the end.
His defense at first, right? I mean, there are reasons why he pleaded guilty that have nothing to do with the charges. His defense was he was entitled to combat immunity, right? Because the United States is involved in an armed conflict, and so presumably whomever the subject of force is in the armed conflict is also involved in the armed conflict, and therefore is allowed to participate openly in said armed conflict with the same privileges and rights that U.S. soldiers would have in the other circumstance. Suffice to say that argument didn't go very far, right? But it does reveal the danger. We've come to really accept now, 10 years past 9/11, this sort of simultaneous operation of the criminal and military paradigm to dealing with the war on terrorism, right? And I think what the question touches on is the most profound danger of accepting that without deep consideration, which is that the more we think of the war on terrorism, or whatever the heck this is, in military terms, the more we open ourselves up to that argument, right? So if a civilian contractor can kill someone like Anwar al-Awlaki in Yemen by pressing a button in a windowless room in Northern Virginia, can Anwar al-Awlaki's friend then kill the civilian contractor on his way home from work, right? The more that we want to treat the war on terrorism as a military paradigm governed by the rules of international humanitarian law, the more we open ourselves up to that argument. right? Whereas in the criminal law paradigm, there's no such thing as reciprocity. The police get to do things that we don't get to do, right? And I think that's exactly the problem with the merger that we've seen over the last.
And one of the problems all of us are having up here is that we all know that there was a classified 50-page memo that was written by the Department of Justice that gives the administration's legal rationale for killing Olawaki. Now, all of us would love to get that so we could read it and say, is it right? But without having access to that, to my knowledge, it hasn't been leaked yet. Hopefully it will. But we all are trying to find out exactly what the administration says its rights are. We are all speculating up here.
Including the latest person to join the call for greater transparency in executive branch operations, David Addington.
So
A Duke law grab.
we find ourselves at the end of our time. First, I would like to give a round of applause to our reiterate our thanks for the Newkirk Center for Science and Society and the Center for Unconventional Security Affairs for helping to plan and co-host this. Our colleague Joe Demento for his assistance, and to let you know that there is a reception that will be held just outside in the courtyard for the next hour. But thank you very much for your participation.